So what happens when a truly noble cause crashes headfirst into the absolute unforgiving wall of courtroom procedure? Well, welcome to this explainer. Today, we're unpacking a really fascinating 1997 decision from South Africa's Constitutional Court. This is case CCT 21/97, and it sets up this ultimate classic clash between passionate environmental activism on one side and rigid, unbending legal rules on the other. It's a textbook cautionary tale. It proves that, hey, having the moral high ground, that doesn't give you a free pass to just ignore the rule book. Okay, let's dive into this roadmap. We've got 6 parts today: the environmental dispute, a procedural disaster, seeking direct court access, the court's strict rules, why good intentions aren't enough, and then the final verdict. Starting right off with Section 1, the environmental dispute. The whole setting for this dispute is Hekpoort. It's this small agricultural district right at the foot of the Magaliesberg Mountains. And this quiet rural community suddenly became the staging ground for a massive legal showdown over the very environment that defines it. We are looking at a total David versus Goliath setup here. On one side, the first applicant, the Hekpoort Environmental Preservation Society, and they were joined by an agricultural worker named Willem Lowe. Their main, terrifying allegation was that irreversible pollution was actively poisoning the underground water supply. Then, on the other side, the respondent, Hekpoort Foods CC. They run a sorghum beer factory in the area. And look, Hekpoort Foods wasn't just brushing these claims off, they were fiercely denying them, and they came armed with their own comprehensive expert testimony. Now, think about this number for a second. 400. When the society first launched their application in the High Court, their founding papers ran to nearly 400 pages, just packed with different expert reports. But Hekpoort Foods fired right back. Their answering affidavit was also over 400 pages long, aggressively contesting every single claim. In the legal world, that means you have a massive, sharp dispute effect. When you've got battling experts and literally hundreds of pages of totally contradictory claims, no judge can just sit there, read the documents, and magically decide the truth. A court actually has to hear live oral evidence to figure out who's right. Moving to Section 2, a procedural disaster. Because as it turns out, the society quickly became their own worst enemy in the High Court. Tracking the progression of their case is honestly agonizing. It was slow and really messy. The alleged pollution by the factory was actually public knowledge by mid-1994, yet the society waited almost 2 full years until March 1996 to actually launch their High Court application. And when they finally got around to it, they didn't even bring it as an urgent matter. Worse still, in July 1996, they just ignored the uniform rules about setting a case down for a hearing. And get this, they did this even after the respondents explicitly warned the society's legal advisor that they were violating the rules. The result? The case was struck right off the roll. And the consequences for ignoring those court rules? Absolutely severe. Let me translate this heavy legal jargon into plain English for you. Step 1. The court ordered the society to pay wasted costs on an attorney and client scale. That is a harsh, punitive financial penalty for wasting the court's time. Step 2. They were legally barred from proceeding with their case until they furnished security for the factory's costs. Basically, they had to put down a massive financial deposit to guarantee they could cover the factory's legal bills if they lost. And then Step 3, their attempts to add Willem Lowe to the case and appeal these decisions were just flat out dismissed. So they hit a massive, terribly expensive brick wall that was entirely of their own making. Which brings us to Section 3, seeking direct court access. Facing those seemingly insurmountable financial and procedural roadblocks down in the lower courts, the society tried a desperate maneuver. They attempted to bypass the Supreme Court entirely and take their environmental fight straight to the highest court in the land. To do this, they relied on Constitutional Court Rule 17. And this brilliantly illustrates how the law reserves special mechanisms for true emergencies. Rule 17 is essentially a legal Hail Mary pass. It's this extraordinary bypass that grants direct access to the Constitutional Court. But, and this is a big but, previous rulings explicitly state it's permitted only under highly exceptional circumstances. It is definitely not a shortcut for people who just want to skip the queue. Right? So the society argued that this was an exceptional circumstance. They pointed straight to Section 34 of the 1996 Constitution. This section guarantees everyone the right to have a dispute resolved in a fair, public hearing before a court. The society argued that because they couldn't afford that heavy security for costs ordered by the lower court, they were effectively being prevented from exercising their constitutional rights to protect the environment for the general public. They basically claimed, look, if the Constitutional Court doesn't step in right now, irreversible environmental damage is going to happen. Now for Section 4, the court's strict rules. But here's the thing. The Constitutional Court had to look at this completely objectively. They had to strip away the emotion of the environmental cause. The highest court is governed by rigid logic, and frankly, they were deeply unimpressed by the society's attempt to blame the factory for their predicament. See, the society had accused the factory of prejudicing the ends of justice by delaying the case for a year and a half. But the Constitutional Court impartially reviewed the timeline and completely rejected that narrative. The court noted that the factory owners, the respondents, were merely protecting their own interests in conformity of the law. The factory didn't delay the case. They simply used the legal protections available to them when the society repeatedly decided to ignore the rulebook. Section 5. Good intentions aren't enough. This leads us directly to the foundational takeaway of this entire judgment. The court drew a very strict, undeniable line between fighting for a noble cause and actually complying with procedural law. Judge Ackermann delivered this rather harsh truth in his judgment, stating, "Moreover, the predicament in which the society finds itself is largely of its own making." I mean, ouch, right? The court had absolutely no sympathy for a crisis that the applicants created themselves by waiting 2 years to file, messing up the scheduling, and ignoring direct warnings from the opposition. So the crucial point is captured perfectly in this second quote. Judge Ackermann fully acknowledged that the society was genuinely concerned with the environment, and they were acting in the public interest. But he declared that even the most public-spirited of litigants cannot simply ignore those procedural rules, which are designed to regulate the fair and orderly dispatch of court business and the protection of the rights of all. The takeaway here, no matter how righteous your cause is, the rules apply equally to everyone. You simply cannot break the rules of the lower court and then ask the highest court to swoop in and save you from the consequences. Finally, Section 6, the final verdict. With that stern reprimand, the Constitutional Court unanimously handed down a decisive ruling. The application for direct access was refused. Let's just logically walk through exactly why the court shut this down. First off, those 400-page affidavits created massive factual disputes that absolutely require oral evidence, and that is something the Constitutional Court is just not designed to hear directly in an application like this. Second, the applicants blatantly ignored procedural rules, meaning there were zero exceptional circumstances to justify a bypass. Third, if the society really believed the costs order violated their constitutional rights, they should have raised that constitutional issue in the lower court first, not just tossed it in as an afterthought. And lastly, the court pointed out a huge technicality. The High Court case was actually still pending. The Constitutional Court just doesn't have the power to take over an active case from a lower court as if it were the court of first instance. Which really leaves us with a highly provocative thought. The Constitutional Court was absolutely right to uphold the law to protect the fairness of the system for everyone, but it forces us to ask a tough question. If justice requires these strict, expensive, and unforgiving procedural rules, how can underfunded, well-meaning activists actually protect the environment before irreversible damage is done without falling into these procedural traps? It's a really delicate, difficult balance between ensuring a fair legal process and facilitating urgent environmental action. And honestly, it's a tension that remains just as relevant today as it was back in 1997. Thanks so much for joining me for this explainer, and I hope this deeper look gives you a whole new perspective on how the gears of justice actually turn.